It's just in time. I know it's really hard when we're kind of approaching after hours and you have a call scheduled at 4 p.m. and it's, 4:55 and it's like, oh gosh, I have to, wrap it up before
Yeah.
logging
I
on here.
I told Pamela, I'm like, Pamela, please, no calls after 3 on a Tuesday.
Yeah, it's so hard, especially with our team meetings and everything too, to kind of fit everything in. It feels like so much of the day is um yeah, jumping between calls and jumping between meetings, but yeah. Tuesdays, for whatever reason, are just always hectic that way.
Hey, at least it's not the Monday, right? Imagine having, yeah,
Very true.
It would be more painful if it was on a Monday.
yeah.
Yeah, absolutely.
It's 5 o'clock on the dot now, so I'm gonna get us started. Welcome to all our audience, and are we live on YouTube today? We are live on YouTube, so welcome to our YouTube members as well. Welcome to After Hours. Glad to see everyone joining in. Quick housekeeping before we begin. There is no chat function available in our Zoom call, but feel free to use the Q&A feature at the bottom of your screen to submit your comments or questions. While we are here to provide insights on separation and divorce and family law, please remember that any information that we share in this series should not be taken as legal advice. Today we are talking about same-sex divorce laws in Ontario. So for people who are in same-sex relationships, who are going through a divorce, this is a chance for them to get to know a bit more about their rights and how the divorce process works in Ontario. And towards the end, we will be sharing how you can get a free 20-minute consultation with one of our lawyers. So stay tuned towards the end. I will now move on to introductions. We have with us our usual Stephanie Burke. Stephanie has been with our firm for quite some time now. She's been immersed in family law for over 6 years, advocating for clients both inside and outside of the courtroom. Steph has obtained a successful result from an ex parte motion, which is published on Canly, so check that out. What drives Stephanie's passion is the positive difference she can make assisting clients through what is traditionally a difficult time by approaching matters with empathy, integrity, and compassion. We also have Joe joining us. Joe is a compassionate family lawyer driven by a deep desire to support families through challenging times. With a background in commerce, he brings strong negotiation and critical thinking skills to his legal practice. His passion for family law was further honed through legal writing, research, and hands-on experience in the family and children law placement at Queen's University. During his articling period, he gained confidence in handling a wide range of family law matters. Joe emphasizes active listening, clear communication, and empathy, fostering a comfortable environment for clients to discuss personal matters. Next up, we have Jodeen. Jodeen is an articling student at RIA, and she is the newest member of our firm. Despite her relatively short time with us, Jodeen has already gained valuable experience across both collaborative and litigation files. Her legal journey began at Queen's University, where she honed her advocacy skills through roles at the Neighborhood Legal Services Clinic and the Family and Children Services of Frontenac, Lennox, and Addington. These experiences helped her develop a keen ability to navigate complex legal issues with empathy and insight. Outside of work, Jodeen enjoys trying new and exciting activities, the most recent being ultimate frisbee. Lastly, there is me. I'm a family lawyer with a strong focus on compassionate and effective legal representation. My background in business management enhances my strategic approach to legal matters. I excel in negotiation, achieving favorable settlements through strategic dialogue and strong advocacy for my clients. I prioritize clear communication, ensuring that clients are informed and empowered throughout the legal process. Without any further ado, I will now jump right into our topic. And I will start us off by providing a bit of an introduction um, on same-sex laws, separation and divorce laws in Ontario. Right off the bat, whether you are a heterosexual couple or a same-sex couple, the laws that apply to you are the same. It's really important to understand that same-sex couples are treated the same as opposite-sex couples when it comes to divorce. Both are governed by the same laws. We have the Divorce Act and the Family Law Act that ensure that all married couples, regardless of their gender, are treated equally throughout the process, which promotes fairness for everyone that's involved. Equality in the divorce process so that all married couples, like I said, regardless of gender, receive fair treatment. For example, both partners who are going through separation have the right to claim spousal support and assets accumulated during the marriage. Make sure those are divided equally. When children are involved, laws that ensure the best interest of the child are prioritized without any bias towards gender or sexual orientation of the parents. It is common for people to come to Canada from countries where same-sex marriage is not recognized, and they come here to legally get married, and then they go back to their country. Now, if these couples, they want to divorce, there is a requirement for couples in Canada to live at least 1 year before they could apply for divorce. Now for non-resident same-sex couples who came to Canada to get married, this was an issue. They couldn't get divorced in Canada unless they met this residency requirement. Thankfully, this has changed. Now, non-resident same-sex couples who were married in Canada can now apply for a divorce here without needing to live in the country for a year. However, instead of going through the regular Divorce Act, they'll apply under the Civil Marriage Act. There are some requirements, including that neither spouse lives in Canada and that they're unable to get divorced in their home country because the marriage there isn't recognized. So moving on, let's talk more about what we are here for, which is legal rights and protections provided to same-sex couples. When I say protections are provided, what protections are there? And perhaps, Joe, you can talk more about it and tell us a little bit more.
Yeah, sure. So in Canada, same-sex couples, they have the same legal rights and protections under family laws, as Shanza mentioned, as I'm going to use the term opposite-sex couples. These rights have, evolved significantly, particularly after the legalization of same-sex marriage in 2005. And, turning back to marriage and divorce, right? So same-sex couples do have the right to marry and divorce under Canadian law, as Shanza mentioned, as recognized by the Civil Marriages Act, and that was passed in 2005. And that legalized same-sex marriage nationwide, not just in Ontario, not just in Quebec, but all of Canada. And the rules regarding divorce, including the division of property, spousal support, child support, all apply equally to same-sex marriage couples as they do to opposite-sex couples. And that's, as Shanza said, it comprises under what's called the Divorce Act. That's the federal legislation we use when we're dealing with married spouses, whether that be heterosexual couples or same-sex couples. And we're going to dive in deeper into, with respects to parenting and property division and how that equates to same-sex married couples. And, just forewarning, I'm going to give you the quick answer. It applies the same way as it does to heterosexual couples. Turning now to common law relationships, right? So same-sex couples in common law relationships, which means they're living together in a conjugal relationship, but they're not legally married, and they have similar rights and responsibilities to those who are legally married. However, different rights are granted to those who are common law versus married. It doesn't matter if it's same-sex or not. Those laws are the same rights and obligations to common law are set for common law, and the rights and obligations for married couples are set regardless of same-sex or heterosexual. And regardless, out of, in the totality of things and everything that comes into play, Canada's Charter of Rights and Freedoms, as well as each province's specific human rights codes, protect same-sex couples from discrimination in family law, as well as all other areas. And this, ensures that same-sex couples cannot be treated differently from heterosexual couples in legal proceedings or, even societal contexts, right? So the process that's for same-sex couples is the exact same process for straight couples or heterosexual couples.
Thank you, Joe. That's a great overview. And you kind of like listed the different type of issues that, these couples, regardless of, whether you're same sex and opposite sex, the type of issues that they deal with, like parenting, decision making, spousal, child support. So let's do a bit of a deep dive in all of these different issues. And we can start with parenting. Steph, I will turn to you. What legal rights do same-sex parents have in terms of parenting and decision making? Are there challenges or any obstacles or any considerations in general that same-sex couples must take into account when dealing with parenting issues?
Yeah, so when we're looking at parenting issues, before jumping into really, um, decision-making responsibility, parenting time, all of these components that the Children's Law Reform Act and the Divorce Act touch on when, navigating to separating spouses and what happens with the kids. One of the things that I find very interesting and something that's, worth noting is in Ontario, issues around parenting, we know they're governed by the Children's Law Reform Act or the Divorce Act. Until recent reforms, the Children's Law Reform Act didn't actually address situations where children had, whether it's more than two parents, parents who are of the same sex, or children who are born from modern reproductive technologies or surrogacies, things like that. So it posed a particular challenge for same-sex and LGBTQ plus parents. In 2017, legislation did come into force. It amended provisions that govern parentage to foster equality and inclusion. So that was the All Families Are Equal Act that was implemented, and it shifted the consideration from parenthood derived from biology to parenthood derived from intention. So following that, there was some more legislative amendments to the CLRA, the Children's Law Reform Act. So now it does recognize many different ways to determine who is a parent. It also touches on who is not considered a parent. So it touches on birth parents, spouses of the birth parent, up to 4 people who are preconception parents pursuant to an agreement. If a person was living in a conjugal relationship with the child's birth parent before birth, and if they were separated after 300 days of the child's birth. So all of these things to consider who is a parent and who has these rights as a parent within family law and parenting arrangements, things like that. So I won't go too deep into the different rules and the different sort of what counts, what doesn't. That's kind of a topic for another day. But if our audience members did want to learn more about the different circumstances and the different kind of rules around that, you can go to the Children's Law Reform Act, and it's kind of all listed under rules of parentage. So ultimately, the legislative scheme now does prioritize, like I said, defining who is a parent based on intention. And that kind of leads into, well, what happens once two parents, regardless if they're opposite sex, same sex marriage, or common law, what happens if you separate? What happens to the children? So we've talked, extensively throughout the course of the series about what's the best interest of the child. And ultimately, it comes down to that. When we look at arrangements for parenting time and decision-making responsibility, formally in previous legislations, it was called custody and access. The end goal, whether you're negotiating an agreement or you're in the court process, the test is what is in the best interest of the child. It doesn't always mean 50-50. There's no necessarily default rule that it's 50-50. Historically, there was this maximum principal rule. The courts have sort of shifted away from that, and it ultimately comes down to, when the child is in each parent's care, are they looked after? Are they supported emotionally, physically? Is their well-being taken into consideration? Is the parenting arrangement appropriate given the age and the needs of the child? Are the parents still located in similar jurisdictions where, every other week it makes sense? So there's so many things to consider, but ultimately, because of the legislation and because of the progression and all of this, change to our laws and our the Children's Law Reform Act, regardless of if you are an opposite sex couple, same sex couple, the rules still apply, and ultimately, it's a child-focused approach. So that's kind of from the parenting component, but yeah.
Thank you, Steph. That was a very great overview there. And thank you for also going into some of the unique issues that same-sex couples, also can find themselves into as they're navigating the separation process. I just have a client and, we're looking at paternity tests. And when you're looking at same-sex couples, their issues can be very different in determining who is a parent, right? So that was a very great overview. Now let's switch gears a little bit and talk about the financial side of things. And Joe, I will now turn to you. How are assets and debts divided between same-sex spouses in Ontario under family law? Do same-sex couples have the same rights, for example, towards a matrimonial home, pensions, and other shared property as opposite-sex couples?
Yeah, so the short answer is yes. I mean, going back to my discussion previous, the laws don't change whether or not couple is heterosexual or a same-sex couple, the laws apply equally to everyone. However, in terms of how those laws apply, the only difference being is whether or not the couple is married or they're common law. So with respects to property division for married couples, it's governed by our provincial statute. It's known as the Family Law Act, and each province has their own Family Law Act. And in Ontario, obviously, it's the Ontario Family Law Act. And regardless of whether they're, like I said, heterosexual or a same-sex couple, the same principles apply. So going back to the idea of division of assets and you said division of debts as well. So the equalization of net family property. So net family property is the difference between each spouse's assets and liabilities or debts from the date of marriage to the date of separation. So that's how we calculate each spouse's net family property. And the net family property excludes the value of assets that are owned at the time of the marriage, except for the matrimonial home. And the spouse with the higher net family property must pay what's called an equalization payment. And that's to the spouse with lower net family property. And that's to ensure there's an equal sharing of matrimonial assets. We've had discussions in the past about how division of property works. I'm not going to get into the finer details. I'm just going to sort of keep it on basic level on a bird's eye view. But with respect to the matrimonial home, both spouses, regardless, like I said, heterosexual or same sex, have an equal right to live in the matrimonial home, regardless of whose name is on title. And the value of the matrimonial home is included in net family property, even if it's owned before marriage. So it's one of those exceptions that we have, one of the many exceptions we have when determining each party's net family property. And with respect to the matrimonial home, it cannot be sold or encumbered with the other spouse's, without the other spouse's consent. So what does it mean by encumbered? That means you cannot assume any charges, mortgages, liens on the home without the other person or without the other spouse's consent. Going back to exceptions as well, we've talked about it. There's also the idea of excluded property. Exclusions may include things such as gifts or inheritances that were received during the marriage, property that was owned before the marriage, whether that be intangible or tangible assets, except the matrimonial home, of course. There's specific designations with that, as well as personal injury awards or insurance payouts. And that's in some cases because there are certain aspects of personal injury awards and insurance payouts that actually can be attributed to net family property. However, for all intents and purposes, we're going to say that personal injury awards and insurance payouts, oh, we got a guest, are not included and they are exclusions. With respects to pensions and retirement accounts, pensions and retirement accounts are part of the NFP calculation and they must be shared upon separation. And sort of that comprises everything that deals with the division of assets and debts with respects to married couples. Now, the difference between property division for common law couples, that is an entirely different regime. Like I said, whether or not heterosexual same-sex couple, this applies to everybody. And common law partners do not have an automatic right to property division. And sir, please move over. They don't have an automatic right to property division like married couples. And each partner typically retains property in their name upon separation. So if there's no automatic right to property division, that also means that there's no automatic equalization, right? So that means there's no entitlement to an equalization of property for common law partners. But how do partners go about going forward with putting claims with respects to property? Well, partners can make claims under what's called a constructive trust or an unjust enrichment if they've contributed to property that's owned by the other partner. And a constructive trust is a claim for an equitable interest based on contributions, whether that be financial contributions or if that's labor, so it'd be considered as a non-financial contribution. And then there's what's called unjust enrichment, which is a claim for compensation if one partner unfairly benefits at the expense of the other, right? And dealing with maybe there's property that's jointly owned, whether that be a jointly owned bank account or jointly owned properties, investment properties. Those properties are divided according to ownership shares. And so what does this mean, whether or not you're married or you're not married? What happens if there are agreements involved, contracts, marital contracts, right? Those can be either prenups or cohabitation agreements, depending on whether or not the parties are married or not, right? So a prenuptial agreement will deal with married couples, whereas cohab agreements will deal with common law couples. And those agreements can specify how property will be divided upon separation. And these agreements can override default property division rules that's outlined in legislation and help avoid disputes down the line. Now, finally, turning towards debts and liabilities. So with respects for married couples, debts that are incurred during the marriage are factored into the equalization process, but for common law couples, each partner is responsible for debts in their own name unless, otherwise agreed to. So what could we take away from that entire, mixed, jumbled session? Same-sex couples do have the same property division rights as opposite or heterosexual couples. With respects to married couples, property is divided equally through the equalization process. For common law couples, property division is based on individual ownership, and agreements such as prenups, cohab agreements can change all that. They can change how the legislation is, and it applies, specifically and tailored to your instance. So I know that was a lot of information thrown at our audience, but unfortunately, with respects to property division, there is a lot of information because it does matter whether or not the parties are common law or married.
Yeah.
Thank you, Joe.
I'm
Go
just
ahead.
gonna jump in quickly. I see some Q&As popping in. One just touches on what Joe you've been talking about when we want to talk about equalization. And if equalization payment can be forced to be paid from a particular asset, whether that's a pension or RRSPs or something like that. Joe, do you want to answer? I don't mind taking it, or if we can just kind of have a round
Yeah,
table.
sorry, I'm just looking at the questions. So with respects to pensions, um, pensions are incorporated if they're a married couple. They form part of the net family property. So as such, whether or not it varies whether or not the pension's already in pay or if it's not in pay yet. But typically speaking, if the pension is not in pay, then that value will be attributed to the respective spouse's net family property. And that comes into play with respects to what is first of all, whether or not one spouse does have a greater net family property than the other, right? That's the first thing that needs to be determined. But secondly, sometimes it results in property needing to be sold in order to fulfill that equalization payment. So it may not necessarily come directly from the pension. It can be from the matrimonial home that needs to be sold in order for that one party to be able to pay the equalization payment, right? So there's different ways that we can go about it. Sometimes it is specific to one asset. More often than not, it is the matrimonial home because more often than not, that is the largest asset between parties. But yes, it could be the pension as well. So it all depends how much the equalization payment is and in terms of where we're going to be able to seek that value from.
Yep, you answered that right on, Joe, and I apologize. I asked you a very loaded question. Generally, when we're doing our after hours, we have each hour, talking about each and every one of these issues. And right now, we're just trying to give you as much information as we can in the limited time that we have. So that was very informative. So let me move on to our next topic now, which is spousal support. And this is a big topic too for couples. And let me just give you a bit of an overview on how the spousal support laws apply to same-sex couples. And like we keep saying, the laws treat same-sex couples the same as opposite-sex couples, ensuring that both groups have equal rights and protections regarding spousal support as well. So when a couple separates, sometimes they will seek financial assistance through spousal support, which is designed, so the spousal support is designed to address economic disadvantages that one spouse may face as a result of the marriage or relationship breakdown. Before any spousal support, however, can be quantified, first thing that we need to establish when it comes to spousal support is entitlement. The spouse seeking support must be able to demonstrate that they are eligible to receive it, and entitlement can arise on two main bases, compensatory and non-compensatory basis. When we're looking at compensatory basis, that focuses on compensating a spouse for sacrifices that they have made during the marriage. For example, let's say one spouse gave up their career to either support the other's career or to manage the household or the kids, then that spouse may be entitled to support to make up for the economic disadvantage resulting from that sacrifice. we also have non-compensatory basis for support, and this basis considers the need for support without linking it to specific sacrifices made during the marriage. Here, the court will look at things like they will look at the financial situation of both spouses after separation. It will look at their standard of living during the marriage and ongoing need for support. If one spouse cannot support themselves due to, for example, their age, health issues, or other circumstances, then they may be entitled to support on a non-compensatory basis. So that's the first step. Once entitlement is established, whether through a compensatory or non-compensatory or both basis, the court will then determine the quantum or the amount of support to be paid. Now, several factors will influence this decision. We will look, you look at the length of the relationship, the financial circumstances of both parties, their roles, the roles that each spouse played during the relationship. It's important to note that spousal support is not automatic. We strive for a balanced approach, seeking fairness for both parties involved, while always considering, each case's unique circumstances. In Ontario, we have the spousal support advisory guidelines. They provide a range of support amounts, and they also provide a range for duration based on the couple's situation, such as income and the length of the relationship. There are formulas in the guidelines as well that delve into, what duration you're looking at, what amount you're looking at. We just don't have the time today to go into a lot of details about all of this, but we have done a session on this topic in the past, so feel free to go on our website and our YouTube channel. You should be able to find some videos on there as well. Last thing I'll hit on is that, if you have children and there is child support as well, then spousal support obligation can be intertwined with child support. Child support is typically prioritized. So if you have children and child support obligations, and in cases where a spouse's ability to pay both is limited, then child support obligations will take precedence. Okay, so I think we've managed to give a bit of an overview on many of the issues that comes with separation and divorce. And I'm gonna jump into Jodeen now. And Jodeen, perhaps you can cover some challenges that, same-sex couples usually will force in a divorce scenario. And, when they're separating and they're going through a divorce, can you talk a little bit more about that and, rights and responsibilities and challenges just specific to, same-sex couples, and kind of take over from here?
I will try to cover as much as that as possible. Yes. So for same-sex couples, just as we have mentioned before in the segment, they are treated legally the same as opposite sex couples. And however, before legal recognition, same-sex couples didn't have those protections in family law situations, like when it came to separation and access and parenting time, like all those things just didn't really exist for same-sex couples in the way that it has and continues to exist for opposite sex couples. And even though the law has changed, yes, we are making, but unfortunately, there's still some societal perceptions and barriers that add stress, especially to same-sex couples who are looking to separate. So, discrimination can still arise, depending on, well, not depending on, but so it's important to know that when you're reaching out for help and assistance, that you're the person who you're receiving that help and assistance from is LGBTQ friendly, and will seek to understand your issue as uniquely as your relationship is. So as unique as your relationship is. So because not all, it's not all cut and dry in the same way that it is for opposite sex couples. And sometimes because society is so stuck in thinking of things in a heteronormative way, traditional ways of approaching divorce, separation may carry over into your relationship as a same-sex couple. However, it doesn't necessarily apply in the same way. So so some of the things that were mentioned before was like parentage and how that may look differently for same-sex relationships. Thankfully, now we have some important changes to legislation, which have allowed a more streamlined and clear approach to who the parent is, understanding who the parent is, and which is important because that was a source of contention for a long time for same-sex relationships, because the way that couples may have conceived their child is not how hetero couples would necessarily do it. And therefore, the law was kind of lagging behind those changes in how we see families being created. And Steph mentioned a lot of those things already, and they've been mentioned throughout. So I won't dive into that too much, but we are able to understand what birth parent means, and reproductive material donors, conception through intercourse is one we already knew before, but spouse of the birth parent, we were able to understand those designations and who occupies those roles as they are clearly outlined in the CLRA. There are also preconception agreements, as well as surrogacy agreements, which are outlined in the CLRA as well. So that has provided a lot more guidance to same-sex couples on their options when they're looking to separate or divorce, and if children are involved in the relationship. And Steph also mentioned the amendments to the Civil Marriage Act, which help clarify that marriages performed in Canada remain valid, even if one or both of the spouses lack capacity to marry under their own jurisdiction's laws, which means that, your divorce, if you get it here, it will still be valid. So those details were provided to you earlier by Steph and Joe, and I think Shanza touched on that too. But at the end of the day, divorce is divorce, and it's tough. So it's a very challenging time, and you must ensure that both or individually or together, that you are taking care of your emotional and mental states. And so I think after this, there are some resources that will be provided so that you can access what is appropriate for you. And I did put together some resources specific to same-sex couples as well as general resources to help you navigate family law issues more generally. So, yeah.
Thank you, Jodeen. You're right. I think it's important to recognize how the societal attitudes and these challenges can really shape the experiences of same-sex couples. It can influence everything from their relationships to parenting to their interactions with the legal system and the community. And it's important to talk about these things and how they can impact the experiences of same-sex couples as they navigate the legal system, as they navigate their separation and their divorce. You also mentioned how the courts have played a role in addressing these attitudes and these challenges. And I'm hoping, Steph, if you can kind of talk about some cases or some examples of that highlight key legal challenges or outcomes, and any valuable insight that we can take from these cases and how the courts have handled these cases in the past.
Yeah, absolutely. The one that really stands out the most, in my opinion, is sort of the case back in June of 2003. It was Halpern in Canada. So this case went all the way to the Court of Appeal in Ontario. And the result, or sort of the outcome of this case, was that the court found the common law definition of marriage, which previously defined it as between one man and one woman, it violated the Charter of Rights and Freedoms. So specifically Section 15. So following this case, that sort of sparked and implemented the change, not only in Ontario, and then, Quebec and BC followed suit, and ultimately it became, nationwide, the Civil Marriages Act, and that was officially passed in 2005. So any instant where you see spouse or marriage, it encompasses both opposite sex or heterosexual partners as well as same-sex partners. So that one was really pivotal, and something that really sparked the needed change to our legislation. Concurrently, the divorce laws that apply to same-sex and heterosexual couples, it 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 also applies to the Divorce Act. So one of the challenges that we can see, and Shanza, you touched on it a little bit earlier, is under the Divorce Act, in order to get a divorce, one of the spouses have to be habitually a resident in the Canadian province for at least 12 months. And then the other element to obtain a divorce is that the spouses have to be separated for over a year. So the problem that the legislation hasn't necessarily fixed, or it can still pose an issue to same-sex couples that the heterosexual couples might not face, is when a couple is married in Ontario, it's a valid marriage, and then they either move to or are a resident in a different jurisdiction that doesn't recognize the marriage. So in those situations, the couple may encounter issues seeking a divorce at all, as that jurisdiction either doesn't recognize the marriage, and then they're also bound to this habitual residence requirement, so they can't obtain the divorce back in their the jurisdiction where they married. So the other complication with that is the protections that divorce and married couples have, which Joe touched on, especially when talking about equalization of property. If you are a same-sex couple that wants to divorce, but you're in a jurisdiction that either doesn't recognize your marriage or doesn't afford you the same protections as a married couple in a jurisdiction like Ontario, you may, face hardships in terms of pursuing that type of entitlement. So division of property, spousal support, things like that. In 2013, to try to remedy the issue of obtaining a divorce, the Civil Marriage Act did have some amendments. So it allowed the province where a non-resident couple can get a divorce granted to them. However, it doesn't encompass I can never say this word properly, the corollary relief, which is that division of property and spousal support issue. So there's still a lot of holes in our legislation, unfortunately. That's something that, hopefully through time and education and proper reform, we can get there. But that's just some of the legislative holes that still need to be filled. Just kind of going back off of what Jodeen was talking about too, about this heteronormative idea or way of thinking, unfortunately, it's something that I find can still exist. The default is, oh, mom and dad, when talking about parenting, mom and dad. It's, these heteronormative terms that hopefully the courts and counsel and, everyone who's immersed in the legal system will start to reflect on and reformulate their language. But that's just one example that I've noted, in courts and in reading case law and things like that. The terminology is still very deeply rooted in the heteronormative ways. So that's another sort of example of, how we see those struggles or those challenges in our legislation and in our case law.
Thank you, Steph. We're hitting on some big topics today and, talking about these sacrifices, talking about these challenges. Joe, are there resources and support groups available for same-sex couples who are going through a separation and divorce? And can you tell us a bit more about these resources that people have available that they can find some assistance with?
Yeah, I mean, generally speaking, there's really great legal resources that you can seek out. Either that being through the Law Society of Ontario, through Legal Aid Ontario. Each courthouse does have its own family law office where you can get information pertaining to your specific matter in terms like what forms you need to fill out. You may have an opportunity to speak to duty counsel. So there's a lot of great resources in the general aspect. In terms of specifically relating to members of the LGBTQ community, there's various practitioners who specialize in that, and whether that be psychologists, social workers, anyone that you feel that you need to speak to, those are great resources as well. I'm sure there's also other practices, people who don't necessarily specify with the LGBTQ community, that I'm sure are still open to discussing any concerns you have. I know, our firm, we're very open, and, we appreciate all individuals who walk through the door, and we service every client as if they're the same person. So we provide the best service possible to any client who walks through the door. I do know that Jodeen actually does have some specific resources that I believe she is going to share. I'm sure she can speak to it now, but they'll also be included in the show notes as well. Right, Jodeen?
Hi, Joe. Yes, there are some general resources that I did put together, mainly for if you're finding that you're not sure where to turn to in terms of you're having difficulty dealing with your relationship more generally. So not so much the legal side of things, but if you're looking to contact a crisis line and things like that, we've put that together as well. And just for community help, I've put some resources together for that also. And then in terms of for family law resources, Clio has a great, I think it's Clio, has like a great breakdown if you're looking for family law resources, as well as, the Ontario courts also have a great general resource, as Joe mentioned. So yeah, I've put that all together, and that will be shared with you after this session.
Thank you so much, Jodeen. And we have some Q&A coming as well. I kindly ask that we restrict the Q&A feature for questions only to help us stay organized. We have a question coming asking about how, friends and family can help same-sex couples transition through separation and divorce. And I'll just say a few points here. And, it's an open question if any one of you want to kind of jump in as well, Stephanie, Jodeen, or Joseph. But, everything that we've talked about today, we've kind of hit into, some very challenges in history of how same-sex couples have, has dealt with issues in the past. And, as family and friends, I will say that, you provide a listening ear to couples who are going through this hard time, provide them with a safe space to express their feelings and their concerns, active listening without any judgment, allow them to share their emotions and their thoughts openly. We've talked about different resources here. It's always good to offer emotional support. And emotional support can come in many forms, right? You can just be present for them there, you can provide encouragement. You can simply just be there for them to talk, right? Sometimes people just need someone to have a listening ear, to validate their feelings, to let them know that it's okay to grieve the relationship, right? And as they're going through these challenges, just having someone there can really make the process easier. And we have had other, I keep saying this, but we have done sessions on this topic as well, on emotional support and, how you can help your friends and families navigating these issues. So feel free to check out our YouTube and our website to kind of, find more resources there. It's also important to respect their privacy during this time and encourage professional help. Suggesting therapy, counseling can be very beneficial. A professional can really provide a neutral space for processing emotions, navigating challenges of separation. And, lastly, I'll just say, educate yourself on these issues. It's good to have an open mind. It's good to be understanding of, what challenges your friends and families could be facing. And educate yourself, learn more about these things and societal pressures and legal complexities. And this can really help, your friends and family have a more empathetic support when, you're more informed about these issues. So that's a bit of I thought I will kind of like give this little, bow to our talk today, but Steph, Joe, Jodeen, anything you want to, talk more about and hit on, you're all ears.
Yeah,
Yeah,
oh, sorry, go ahead, Steph.
I know.
We both had that look, and I don't know if you were gonna go first, but it's okay, you can go first.
No problem. I think that the biggest takeaway is, despite the history in the past and where the law started years and years ago, and the reform that we've touched on, the different issues around parentage that we touched on, the different issues around common law versus married couples that we touched on, regardless of the gender or the sexual orientation of the two parents or the two spouses, the law now applies regardless. Opposite sex, same sex, that's kind of the biggest takeaway from today. And just something that Joe mentioned, it really hit home in terms of reaching out to counsel or assistance that you feel comfortable talking to and representing you. As lawyers, we are required to be up to date and, open to cultural differences in terms of sexual orientation, different customs. And, we understand that every person is different, every couple is different. So if you are searching for legal assistance, you do want to obtain independent legal advice and you do want representation in your family law matter going forward. That's just one thing that I would highlight and encourage our audience members to think of when trying to find the right lawyer for them. Something I always tell my clients is just like a normal relationship, the solicitor-client relationship is that it's a relationship. It's about the dynamic. It's about how comfortable you feel speaking to your counsel, how transparent you can be. Because at the end of the day, the more that your lawyer knows and the more honest you are with your lawyer, the better they're able to help you. So if you are in the market, you are looking for representation, just keep that in the back of your mind, especially if you have, you're nervous about it or you would prefer representation, a certain gender, a certain, cultural awareness. Just keep an eye out for that and have different calls with lawyers in your area, things like that. Joe, go ahead.
No, I think you summed it up really nice. I was just gonna sort of tag on to what Shanza said about the fact that you're providing that ear for someone to talk to and you're validating their feelings. First and foremost, if someone comes to me with an issue, regarding their taxes, I'm not going to be in a position to provide them advice on that because I'm not a tax professional, I'm not a financial professional. So it's really important too that you're providing resources for people to individuals and professionals that are actually a beneficial or a benefit to their use, right? So if you know someone who's going through legal troubles, don't try to be the person who hops on Google and tries to give them an answer or uses ChatGPT for whatever reason and tries to give them an answer. It's really important that you guide them in the right direction because even if they don't necessarily retain a lawyer, at least getting legal information or even maybe legal advice. If they do retain it, they can, decide where they want to go from there. But it's really important that people get competent legal advice in order for them to make informed decisions. That's our job, is to provide people with the necessary information and competent information to make informed decisions, right? So if you're not in a position to be giving that advice, it's not of that person's benefit to be receiving it. So just making sure that you're guiding people in the right direction, or at least not necessarily to a lawyer, but to other avenues in which they can get, legal information, whether it be through the courthouse, through Legal Aid Ontario. There's so many ways in which you can provide people and put them in the right direction in terms of obtaining legal information.
Thank you for sharing your thoughts and insights, Stephanie, Joseph, and Jodeen. And thank you to everyone for tuning into Family Law, or into our after hours Family Law Now event. Following the session, we will have a brief survey. It will allow you to share your comments and suggestions for future topics that you would like us to explore and talk more about. As always, your feedback is greatly appreciated. And thank you all for sticking around until the end to take advantage of the opportunity for a complimentary 20-minute meeting with one of our lawyers. Make sure to register by noon this Friday. Please provide the code, oh, it's me this time, Shanza 2024, to Nicole in our intake department, and her email is nicole@russellalexander.com. When scheduling your appointment, make sure to share that information with Nicole. We have our next event coming up next week, which is Dating After Divorce, Legal and Emotional Aspects. So make sure you register for our event. Just go to our website, russellalexander.com/familylawnow. Thank you again to our panelists for sharing their insights today, and thank you to everyone on Zoom and on YouTube for tuning into our session today and for all your questions. And yes, have a good night, everyone.
Bye, everyone.
Have a good night.
Bye.